The day the rules of gun ownership flipped forever. Something seismic just hit the legal system. Quiet for decades, then suddenly unstoppable. For years, concealed carry in America was tangled in paperwork, politics, and power games. Licenses delayed, applications denied. Ordinary citizens told to justify their rights, while bureaucrats whispered no. But that era, gone. In a decisive 6-3 Supreme Court ruling, the justices didn't just trim a law. They rewired the foundation of how states can control your ability to carry a weapon. It's not a policy tweak, it's a shockwave. And it's already shaking state houses, overturning old systems, and sending panic through anti-gun networks. You're about to see exactly what this means for every lawful gun owner. No spin, no politics, just straight truth. Welcome to Winds of Thought. Today, what the 6-3 decision truly says, why it's far stronger than headlines admit, how states are reacting or resisting, and what this shift means for you personally. Let's dive in. Chapter 1. The verdict that split the nation. The ruling dropped like thunder. 6 justices stood firm, 3 objected. But beyond numbers, the message was unmistakable. The Constitution speaks louder than state control. That majority wasn't narrow. It was a statement of intent. It told every lower court, follow the original text, not political pressure. This case targeted one state's permit system that forced citizens to ask permission before stepping outside with protection. The court declared, the right to bear arms doesn't stop at your doorstep, doesn't rely on local favoritism, and doesn't demand you prove a good reason. If the Second Amendment covers it, you don't need approval. Period. Chapter 2. The hidden history of control. To grasp why this matters, rewind a century. Permit laws weren't born from safety. They were built to control who could defend themselves. After the Civil War, discriminatory codes targeted freed slaves. By 1911, New York's Sullivan Act used permits to restrict immigrants and the working class. The model spread: high fees, vague rules, endless denials. Courts stood idle. For decades, gun ownership became a privilege handed out by politics, not a right guaranteed by the Constitution. That 6-3 decision shattered that illusion. Rights are not rewards, they're inheritances. Chapter 3. The new test of constitutionality. This wasn't random. It built on the 2022 Bruin decision, which demanded that modern gun laws trace back to historical roots. No more reasonable excuses, no hiding behind public safety. Judges must now ask, would such a restriction have existed in 1791 or 1868? If not, it fails. The latest 6-3 case took that logic and turned it into a weapon against every overreach. Permits, bans, delays, even waiting periods. In short, judges, stop creating loopholes. Start honoring the founding text. Chapter 4. America reacts in real time. Within hours, chaos erupted. Some states scrambled to rewrite laws. Others vowed defiance. California expanded sensitive zones to absurd sizes. Whole districts off limits. New York rushed through a new Carry Improvement Act that many said made things worse. New Jersey added insurance mandates. Texas and Georgia doubled down on permitless carry. Meanwhile, lawsuits multiplied. Pro-gun organizations flooded federal courts with fresh filings. The result? A legal earthquake whose tremors still spread. Chapter 5. The counterattack begins. Anti-gun lawmakers didn't fold, they countered. Their new playbook? Stretch sensitive areas to include parks, parking lots, churches, anywhere possible. Pile on insurance requirements, demand expensive training, delay applications. But there's one fatal flaw. History doesn't back them. There were no no-carry zones in colonial America. Founders didn't seek permits or pay liability taxes to own arms. Every one of these modern tricks is collapsing in court. You can't outlaw freedom just because it scares you. Fear never justifies the removal of liberty. Chapter 6. The Bright Line Standard. This decision didn't just void one statute. It set a universal rule. Text, history, tradition. First, the written words of the Second Amendment come first. Second, judges must look to 18th and 19th century laws, not modern politics. Third, if no equivalent existed back then, today's law falls apart. No public safety exceptions, no emotional balancing, no activist shortcuts. The judiciary just received its reset button, and gun owners gained a shield stronger than ever. Chapter 7. What this means for you. This isn't abstract. It changes daily life. Permit systems demanding good cause, vanishing. Traveling with a firearm? More states will soon honor your license. Traffic stops? Legal carry is presumed lawful, not suspicious. Even shall-issue states might evolve into full constitutional carry. For millions, it's newfound certainty. You're no longer pleading for a right. You're exercising it. Power has shifted from bureaucracy back to the citizen. Chapter 8. The political storm, no ruling this bold escapes backlash. Washington and blue state capitals erupted overnight. New bills, new taxes, new workarounds. Some senators promise modern solutions. Others vow to undo the court's message. Meanwhile, red states are passing freer carry laws in response. The coming elections will revolve around this single issue: control versus constitution. The law may be clear, but politics? That's another battlefield entirely. Chapter 9. The Chain Reaction. The decision targeted permits, but the aftershocks threaten every modern gun control measure. Assault weapon bans are falling. Magazine limits are under review. Waiting periods are collapsing. Sensitive zone expansions are losing in court. Training fees? Challenged as unconstitutional barriers. This time, gun owners aren't on defense. They're advancing. The floodgate is open, and old laws are drowning fast. Chapter 10. A turning point in freedom. Every generation faces a moment when the Constitution is tested. For the Second Amendment, that moment is here. This isn't balancing rights, it's restoring them. It says self-defense stands beside speech, faith, and voting as equal pillars of liberty. It reminds every judge, defend freedom, don't dilute it. Every lawmaker, the Constitution isn't optional, it's binding. This victory isn't just for gun owners, it's for anyone who believes freedom doesn't need permission slips. Your rights, your voice, your future. The rules have changed, and now, so has the balance of power. Stay sharp, stay informed, stay in the fight. This is Winds of Thought, where truth meets clarity. If you found value here, like this video and subscribe so you never miss a breakdown. Share it with someone who believes rights are worth protecting. Stay alert, stay free, stay ahead.